Today we are discussing about one of the most important and most frequently litigated topics in the Calcutta High Court, how to file a service matter writ petition for government employees who have been aggrieved by an illegal administrative action. Hello friends, I am Advocate Sudeep Patra, practicing in the Supreme Court of India and the Calcutta High Court. Whether you are a state government employee who has been unfairly transferred, denied a promotion, dismissed without inquiry, or whose pension has been withheld after decades of service, the Calcutta High Court has the constitutional power under Article 226 of the Constitution of India to protect your rights and provide you with immediate relief. In today's video, which is part of our Calcutta High Court video series, I am going to take you through the entire procedure from understanding which forum you should go to, how the petition is drafted, how it is filed, how it is classified, and what happens in court step by step in plain, simple language. The starting point of every service matter case in the Calcutta High Court is understanding the forum hierarchy. If you are a central government employee, meaning you work in the railways, post office, income tax department, central secretariat, or any other central government organization, the law requires you to first file an original application before the Central Administrative Tribunal, which we call the CAT. The CAT was created by the Administrative Tribunals Act to provide a specialized forum for central service disputes. The Supreme Court, in the landmark judgment of L. Chandrakumar versus Union of India, clarified that the CAT acts as the court of first instance for central employees. Only after the CAT passes an order, whether in your favor or against you, can you come to the Calcutta High Court by filing what is called a WPCT, which stands for Writ Petition Central Tribunal. This WPCT is heard by a division bench of the Calcutta High Court as per the WBAT 2026 roster. That is, division bench I presided over by the Honorable Chief Justice. If, on the other hand, you are a West Bengal state government employee, you must first go to the West Bengal Administrative Tribunal, which we call the WBAT, and after its order, you can file a WPST writ petition state tribunal before division bench of the Calcutta High Court. For armed forces personnel, the forum is the Armed Forces Tribunal, Kolkata bench, and the High Court exercises supervisory jurisdiction over AFT orders under Articles 226 and 227. It is pertinent to mention that any paramilitary personnel, such as CRPF, CISF, and BSF, can directly move to the High Court under Article 226 of the Constitution for any service-related matter before the territorial jurisdiction of the High Court, normally where the personnel is posted or the cause of action has arisen. However, and this is very important, if the tribunal is non-functional due to vacancy or absence of quorum, you can approach the High Court directly under Article 226, but you must demonstrate before the court that the tribunal is actually unable to function and that you will suffer irreparable harm if relief is not granted immediately. Now, let us come to the classification system of the Calcutta High Court, because this is something that even many lawyers get confused about, and a wrong classification can result in your matter being listed before the wrong bench, which costs you weeks of precious time. The Calcutta High Court uses a group system to categorize all writ petitions. For service matters relating to general government employees, whether state or central, the correct classification is Group C, which deals with service regulations. For teachers and educational service employees, the classification is Group 2, and there are specific computer codes for each sector: primary education, secondary education, higher secondary, college, university, library, para-teachers, and madrasa service, with separate codes for selection process, in-service matters, and post-retirement. These codes must be filled in the pro forma, which is Schedule A of the writ petition, accurately, or the court's computerized system will route your matter incorrectly. Now, let us walk through the actual step-by-step procedure for filing the writ petition. The very first thing a government employee must do before approaching the High Court is to exhaust departmental remedies. This means if there is a departmental appeal available, such as an appeal to the secretary, the board, or the next higher authority, you must file that appeal and either get an adverse order or wait a reasonable period without a response. Once you have done that, you must send a demand for justice, a formal legal notice, to the concerned authority, informing them of your grievance and demanding relief within a specific period, usually 2 to 4 weeks. The demand for justice is particularly essential when you are filing a writ of mandamus, the writ that commands an authority to do something, such as release your pension or consider your promotion. Without first making this demand and getting a refusal or non-response, the court may not issue a mandamus. Once the demand for justice has been sent and ignored, you are ready to file the writ petition. The petition has the following structure. First, the title in the matter of an application under Article 226 of the Constitution of India, followed by the name and designation of the petitioner and the names of all respondents, typically the state of West Bengal, through the concerned secretary, the head of department, and the immediate superior authority. The statement of facts follows a chronological, objective, factual narrative of everything that happened, with every fact linked to an annexure. For example, the appointment letter is annexure P. 1. The impugned order is annexure P. 2. The demand for justice notice is annexure P. 3. And so on. After the statement of facts come the grounds of law, the legal arguments, which could include violation of service rules, perversity of the impugned order, malafide exercise of power, or violation of Articles 14 and 16 of the Constitution. And finally, the prayers, the specific reliefs you are seeking from the court, such as issue a writ of certiorari, quashing the order dated so and so, or issue a writ of mandamus, directing the respondents to release pension within 8 weeks. Once the petition is drafted, it must be sworn by the petitioner before a commissioner of oaths. This is the affidavit. The court fee on the appellate side is typically rupees 180 per petitioner. Then, advance copies of the petition must be served on the government pleader and all named respondents. After filing and before the first hearing, an affidavit of service sworn before the commissioner of oath has to be filed during the first hearing. The wakalatnama, the authorization document allowing your advocate to represent your case in court, must be signed and attached. When the petition is filed in the High Court registry, it is assigned a case number, and from there it is listed before the designated bench for hearing. For Group 6 Original Service Matter motions, as per the June 2026 roster of the Calcutta High Court, the designated single bench is SB3, presided over by the Honorable Justice Amrita Sinha. For Group 2 Education Service Matters, the bench is SB23, presided over by the Honorable Justice Ritobroto Kumar Mitra. On the first date of hearing, the court may admit the petition and issue a rule which is a direction to the respondents to show cause why the relief should not be granted. The court may also grant an interim order, for example, staying the transfer or suspending the disciplinary proceedings during the pendency of the rule. It is important to remember the doctrine of Laches. If you delay filing the writ petition for more than 6 to 12 months from the date of the impugned order without a satisfactory explanation, the court may dismiss your petition on the ground of delay alone. So time is of the essence. Friends, the Calcutta High Court is a powerful forum that has time and again protected the constitutional rights of government employees across West Bengal and the Andaman and Nicobar Islands. Whether you are facing an illegal transfer, a withheld pension, a wrongful dismissal, or a biased departmental inquiry, the law is on your side, provided you approach the court correctly, in the right forum, in the right classification, and without delay. Thank you for watching this episode of the Calcutta High Court video series. I hope that this video may have clarified some of the queries by various service matter litigants before the Calcutta High. Subscribe to our channel to get more of this kind of important legal updates.